Aparicio Velencia de la Cruz. Court is plain charging you with intimidating a witness. A plea of not guilty will be entered.
Request for bid. Good afternoon, Your Honor. Thomas Flanagan for Commonwealth. Your Honor, the Commonwealth's request in this matter is that you set a cash bail in the amount of $50,000 to assure the appearance of the defendant at future court dates. The defendant stands charged before this court with willfully misleading police investigators who were involved in the course of an investigation into a double homicide in the city of Brockton, which was discovered by the Brockton police on the evening of Sunday, February 13th. That evening at about 9:20 p.m., the Brockton Police Department received a 911 call regarding a body located inside of a dumpster. The police responded to that address where the caller had described seeing the body, 427 Warren Avenue, apartment 1, north front. When they looked inside the dumpster, Your Honor, they located the body of 25-year-old Maria Palaguachi. In the course of searching that dumpster, approximately 3 hours later, they located a second body identified as the son of Maria Palaguachi, Brian Palaguachi, age 2 years. In the course of the investigation, the police interviewed the defendant before you, Mr. De La Cruz, and they received information from him as to the events that had taken place within that apartment where he lived, in which he shared with the two victims and a fourth person who has not been located yet by investigators and is being sought for questioning. In the course of that interview, which took place shortly after midnight on Monday, February 14th, the defendant before you provided information indicating that the missing fourth roommate, identified to local associates as Luis Guaman, had an argument with Maria Palaguachi. And in the course of the argument, which took place within a closed room, the defendant before you indicated that he had overheard Maria Palaguachi advise Luis Guaman that she did not love him. He then described to the police that he heard voices become raised, and that a short time after that he heard the door of the apartment close and then the outer door to the building close. He advised police that this heated argument between Maria and Luis Guaman was the last time that he saw or heard from either Maria or Brian again. Now, in the course of that interview, Your Honor, the police were attempting to locate Luis Guaman, to interview him, to ask him questions about what had taken place after that argument. And the allegation against the defendant in this complaint is that the defendant willfully withheld information and misled police as to the location that Luis Guaman went to when, shortly after this argument, within a period of approximately 24 hours, Luis Guaman cleaned out his apartment at that address. And according to what the defendant told police, for a period of several days, Guaman indicated he was going to New York, and specifically going to New York City. In fact, in the course of the investigation, the police learned that the defendant before you had told a girlfriend of his who lives in Connecticut and had been telling her since approximately February 12th that he had had a conversation with Luis Guaman, that Luis Guaman indicated that he was going to be going initially to New York, but he also, the defendant, also revealed to his girlfriend that he had personally observed in the possession of Mr. Guaman plane tickets to Ecuador. And according to the investigation, including from statements of the defendant before you, Luis Guaman is a native of Ecuador. Now, for a period of approximately 1.5 to 2 full days, the Massachusetts State Police, the New York State Police, federal authorities as well as the Brockton Police Department, had used the information on the location of this Luis Guaman provided by the defendant to focus their attempts to locate Mr. Guaman in New York City. It was a massive expenditure of man-hours and effort to try to locate him before he would potentially leave the country, because at this time the police were also already aware that he was a Ecuadorian national. The police learned from the father of Brian Palaguachi, who was also the boyfriend of Maria, that he had left the state of Massachusetts to go down to a job in Virginia to work a construction job there. And that when he attempted to have contact with his girlfriend Maria and their son, that he was unable to get through to her for a period of a couple of days on her cell phone. And it was on that basis that the boyfriend returned to Massachusetts. He also had conversation with the defendant. And according to the information provided by Maria's boyfriend, he also was told by this defendant the partial truth and the misleading statement that Mr. Guaman had gone down to New York City. Didn't reveal to him what he had been. The defendant didn't reveal even to the boyfriend, who was expressing concern about where his girlfriend and where his son were. Didn't even reveal to him in his state of upset that in fact Mr. Guaman was headed to New York and then heading out of the country. The basis for the Commonwealth's request, Your Honor, for a $50,000 cash bail is based on this violation of General Laws Chapter 268, Section 13B. The bail request is based on the potential penalty that the defendant faces. Under the statute, the defendant faces a penalty of not more than 2.5 years in the House of Correction or not more than 10 years in state prison. It is a felony. And the evidence received by the police and from this female witness, directly contradicting information that this man had provided the police in the course of this their interview with him, indicates that the defendant before you, Mr. De La Cruz, directly and willfully misled police investigators with the intent to impede, obstruct, delay, or otherwise interfere with a criminal investigation. And I'm going to suggest to the court that in this kind of a charge, a violation of this statute, relatively new, since 2006, considering the seriousness of this alleged offense by the defendant, we must consider two things: the nature of the investigation that was underway and the nature of the lie that the defendant allegedly told. I'm going to suggest to the court that in the police efforts to find the perpetrator and take him into custody into this horrendous double murder, it couldn't be more serious. And the autopsy on these two victims, Judge, once their bodies were recovered from that dumpster where they were left, determined that both Maria and her 2-year-old son, Brian, died from multiple blunt force trauma to the head and to the face area. I suggest to you it's an extremely violent, extremely disturbing crime, and the nature of the misleading by the defendant is also quite serious because it goes to a central fact. Where is this person that had last been seen with Maria and Brian? This person that had last been having a heated and passionate argument about the end of their relationship. And the defendant, while sharing it with a girlfriend covertly, withheld that important information at a critical stage in the investigation. So I'm going to suggest to the court is a very serious offense. And under all the circumstances, Judge, the $50,000 cash bail requested by the Commonwealth is appropriate for the reasons I've stated. I would also point out, Your Honor, that the Commonwealth has been in contact with the Office of the Department of ICE. That's correct, Judge. Immigration and Customs Enforcement confirmed to the District Attorney's Office and the State Police that the defendant is an illegal alien. He's a native of Mexico. And furthermore, investigations reveal that he has no local ties. I'm going to suggest to the court that for these reasons, for lack of local ties, the potential penalty the defendant faces in the circumstances of the offense, that the $50,000 cash bail requested by the Commonwealth is appropriate, Your Honor, as you said. And We're ready to address the Commonwealth's motion to impound the case documents at Your Honor's pleasure. Thank you.
After Your Honor, Judge. No objection to the order.
If I may, Your Honor, there was a final portion of the Commonwealth's argument that I wanted to alert Your Honor to before the defense has his opportunity to address the issue of bail. The seriousness of the alleged offense committed by the defendant in misleading the police as to the whereabouts and the destination of Mr. Guaman is made all the more serious because of the multiple aliases that Mr. Guaman himself has, which makes locating him even more difficult and makes the time lost in the investigation even more precious. He is identified under at least 4 different aliases. Luis Guaman with a date of birth of 5/1/70, who now has a warrant out of the Brockton District Court for assault and battery. He referred to himself to his local associates as Luis Guaman, date of birth of 5/1/77. Under that identification, he has 2 felony warrants out of the state of New York, 1 for kidnapping with malice and 1 for assault. With regard to a 3rd alias, Antonio Castro, date of birth 11/1/80, he actually has a pending Brockton District Court case for assault with a dangerous weapon, to wit a knife. And finally, the 4th confirmed alias for this man wanted for questioning in the deaths of Maria and Brian is Segundo Castro, date of birth 10/4/84, an alias that Luis Guaman, according to the investigation, used to cash a check in the city of Brockton in November of 2010. These aliases have been put together and confirmed as being the same person through fingerprint evidence and photographic evidence, including surveillance photos from the bank in November of 2010. And it's on the basis of those numerous aliases that this wanted individual possesses and has used, making him all the more difficult to locate, which I'm going to suggest to the court makes the offenses in misleading the investigators all the more serious, Judge. Thank you.
Thank you, Your Honor. Primarily, Judge, let's be clear, Mr. De La Cruz is not a suspect in this double homicide. He is merely the last person probably to have seen those 2 people alive. He was their roommates. Mr. De La Cruz, 34 years of age, he born in Mexico, Judge. He came first in the United States through Nevada, came here in Massachusetts around December 22nd, 2010, where he then became a roommate of the 2 victims in this one particular case. He has had very limited contact with this Mr. Guaman. He would stay intermittently in the apartment. She had an ex-husband or father of the other victim, Brian, the child, and he would come and they would often stay back and forth with each other. Mr. Guaman, full-time employee, he's a roofer. Let's be clear, Judge, of what the Commonwealth didn't share with you, is that from the first instance that the bodies were discovered, Mr. De La Cruz was taken into custody, where he sat for 5 hours before he was notified why he was in custody. He was then questioned repeatedly about the 2 victims in this case, if he knew anything, without being shared any information regarding why he's being asked these questions. It's only about an hour and a half into the interview where he's then shown pictures of dead and mutilated bodies of his roommate, of a child, which he cared very deeply for, and just overwhelmed, he begins to start sobbing and crying. The interview then goes on and continues for a period of 3 hours, at which point in time he divulges everything and anything he knows. This allegation by the Commonwealth is contingent upon one factor, the omission, the mistaken omission of the fact that he witnessed plane tickets fall from this alleged suspect, Mr. Guaman's hands. He went to go pick them up and they said Ecuador on them. Now, Mr. Guaman had always said to Mr. De La Cruz, I'm going to New York. When he asked him, he confronted him on the issue of why he had tickets to Ecuador, he said, those are old tickets, that has nothing to do with it. I'm going to New York, and then provided a detailed response as to why he was going to New York. Mr. De La Cruz was completely committed to the fact that he is in New York, and that was his intent to go. He never examined the tickets. The tickets were immediately taken out of his hand. He didn't suspect anything else after that. He was then repeatedly questioned on these facts. He gave he's the one that volunteered the phone number for his girlfriend down in Connecticut. Police at any point in time could have called that girlfriend. Mr. De La Cruz remained in custody and was then released, I do believe, yesterday. He was given $40 to get a hotel room because he refused to return back to the apartment. He hasn't slept since then. He's completely traumatized. The only reason why the Commonwealth gave him $40 to get a hotel room was because he wouldn't leave the police station. Last I checked, Judge, the issue of bail was a presumption of innocence. The suspect's records in this one particular case, which he has done. I haven't seen any evidence that he's an illegal alien, although the Commonwealth makes the representation. I haven't seen it. Judge, there is no fact or circumstance which he will not return and appear for his next court date. I know why the Commonwealth, or at least I suspect why the Commonwealth is seeking to detain Mr. De La Cruz, because he's the only one that saw those two victims last alive. And if Mr. De La Cruz disappears from the planet, the likelihood that if Mr. Guaman is caught, there would be no case for the Commonwealth. Mr. De La Cruz has expressed to me he has 100% committed to the fact that he will do everything and anything he can to volunteer any information to the Commonwealth which would assist them in prosecuting this crime. He is not a suspect in this case, Judge. Anything, as far as the bail is concerned monetarily, would be tantamount to holding him in custody and being detained. I would suggest that his record reflects it is justifiable to be released on a personal recognizance. And Judge, there are conditions which you can attach to that. You can order that he appear twice to probation every day. All he wants to do is work. He's attached such a relationship to two victims in this one particular case. He is not leaving the Commonwealth, Judge, until this is resolved.
Just to clarify, so there's no ambiguity, Your Honor's assessment of the situation, that it couldn't have been clearer from the interview with this female witness in the state of Connecticut, that the conversation that the defendant recounted to his girlfriend, which she then described to police.
I object, Judge. There's no evidence of clarity.
Excuse me, counsel. It's clear as day within the police report, which counsel will provide a copy of. And it's specific in there that this female witness described this defendant telling me that he had spoken with Mr. Guaman. And Mr. Guaman was in the possession of these tickets to Ecuador. And that when Mr. De La Cruz saw them, Mr. Guaman apologized to him and said, "I'm not going to New York, I'm going to Ecuador." And he apologized to Mr. De La Cruz for lying to him. So there's no question about this, Judge, as to any misunderstanding. And furthermore, the police specifically questioned him on the topic of where Mr. Guaman was going to numerous times over that 2-day period, and he withheld it from the police. He told them he was going to New York City. There's no ambiguity about it, Judge. Thank you.
Again, Judge, I suggest there is some ambiguity here. The girlfriend in this one particular case was called in conference with Mr. De La Cruz on the phone. That could have occurred at the first interrogation at 5 o'clock in the morning on February 14th. He volunteered the phone number for his girlfriend. And immediately when he saw the pictures, he remembers that part very vividly. He went into a complete state of shock, gave the phone number to the officer and said, "I really just can't speak right now. If you talk to my girlfriend, she will tell you everything that I know. I just need time to digest this for a minute." It's an awful circumstance, Judge, but the officers had this information and it was available